The new USCIS filing fee schedule is in effect. It is somehow already April of 2024, and like it or not, the new fee schedule is here and it is effective. I'm going to talk today about a few key considerations to take for two major filing groups to make the most of your immigration filing dollars. The first group is, in general, non-immigrant visa petitions. So that means temporary visa petitions. Temporary can be for a number of years. Filings like the H, the O, the L, the E, the TN, the H-1B1, the E3, things like that. So the first consideration for this type of filing, and for the most part, you're going to have to pay. If you're filing with USCIS, you're going to have to pay these new filing fees, right? But one consideration is premium processing. Premium processing in general for this type of filing is currently $2,805, so $2,805. That's not a small amount. So the question is, do you actually need premium processing? That's a case-specific, strategy-specific answer to the question of whether you actually need premium processing. I will say this, sometimes premium processing, an employer will use premium processing because they or the employee want to know that the petition is approved sooner rather than later. Absolutely nothing wrong with that. I have general anxiety disorder. I get it. You want to know so that you can just breathe easy. Totally legitimate reason. But know that you, in a lot of situations, you don't have to pay that amount. I would, before you make that decision, have a conversation internally with us as your immigration law team, look at current processing times and see realistically how quickly are you going to get a decision, and is that something that is tenable for your particular situation? Are you okay waiting maybe 2 or 3 months to get a decision versus 15 business days, which is what you would have with premium processing? So think about premium processing, whether it's actually needed for this case. The flip side of that is there are some times when premium processing for strategic reasons is actually required, either for a person to begin working. So for example, the TN classification does not have portability like the H-1B1, or sorry, the H-1B classification does. So that means that for a TN, if you're going to change employers here within the United States without traveling, that petition has to be approved before you start working. So you probably do want to use premium processing for that. But again, consider when is the start date? When is the anticipated start date? Look at the current processing times and see if it's needed. The other thing is, if the premium processing is not required, absolutely required for the person to begin working, it is permissible for the employee, the foreign national employee, to pay that amount. So it could be that the employer pays the rest of the filing fees and the employee just wants to know sooner rather than later that the petition is approved, or maybe they that particular employee wants to have, for example, an I-140. I know I'm talking about NIVs, but an I-140 approved so that their wife or their spouse rather can apply for a work permit, for example, if they're on H-1B. In that case, you could have the employee pay the premium processing fee. So know that in a lot of situations, and again, ask us if you need clarification, but in a lot of situations, it's possible for the employee to pay the premium processing fee rather than the employer. The other thing to consider with these NIVs is think about, and again, we're here to help you walk through these conversations and decisions, but think about whether it's necessary to apply with USCIS at all and whether it makes sense to have your foreign national travel. Of course, you don't want to impose the fees on, or the travel fees on the foreign national employee necessarily, but a lot of times our foreign national employee clients actually do want to travel. They want to go back home to visit. So for example, if you have foreign national workers, employees who are on classifications like an E visa or a TN or an H-1B1 or an E3, these classifications do not necessarily require that you as the employer file a petition with USCIS before the person can start working in that particular status. So it's fact specific. If they're staying here in the United States, then yes, you're filing with USCIS. But and also the petitions or classifications like the H-1B and the L1, they absolutely require a petition with USCIS, even if the person is currently outside the United States. But there are other classifications, like I said, like the TN, the E3, the H-1B1, for example, where you don't necessarily have to file with USCIS. So for example, let's say that you have an employee on an E2 visa. If that visa is still valid, then the person could leave the United States and re-enter and get a fresh I-94, which is the document that says how long they can stay in the United States, valid for 2 years without having to file an extension with USCIS and potentially without them having to go back to the US consulate to get a renewal. So again, the visa has to be valid. The same thing can be true for other visa classifications. If the person has a valid H-1B1 visa or a valid E-3 visa, in those classifications, they do have to make sure they have a valid LCA as well. But my point is, it's possible for them to travel. Other times, for example, Mexican TNs, the person wants to go back to Mexico to visit, to see family for a holiday, whatever it is. And so the foreign national employee might apply for the TN visa at the US consulate so that they have a fresh visa, so that they're able to, and then that also extends their I-94. That is less expensive sometimes than filing with USCIS, or can be less expensive because right now, the Department of State filing fees are less than the USCIS filing fees. So these are intricate strategies, kind of complicated, level 200, 300 strategies, but know that they are an option, and we're here to help you talk through those options. Changing our focus now to green card filings. So this applies to both employment-based green card filings and family-based green card filings. And I'm talking specifically about the I-485, which is for employment-based filings, it's the last step, the last of two or three major steps in the green card filing process. So the I-485 is filed by the foreign national employee or by the foreign national who's applying for permanent residence. So for example, if you are a US citizen sponsoring your spouse for permanent residence, you file the I-130, your spouse files the I-485 together, usually in one step. Anyway, with the I-485, the big change there is, yes, the base filing fee is going up. It was $12.25, now it's going to be $14.40, I believe. But the big change is previously, until now, the base filing fee, what was $12.25, included the application for the travel document and for the work authorization document. So when I say travel document, that's also called advanced parole. We file using the form I-131, and the travel document, the employment authorization document is also sometimes called the work permit. And you get a card that says that you are work authorized. Those are interim benefits. That means that they are benefits that you can apply for to use while you are waiting for the green card. So when you receive your green card, you no longer need or will use the travel document and the work authorization. You'll use your green card to work and travel. So it's only something that you need while you're waiting for the green card. So you have a couple of things to consider. One is, do you actually need either one of those? So with a travel document, do you plan to travel outside of the United States? If you don't plan to travel, and if money is a consideration, which it is for everyone, right? All the time, then you may not need to apply for the travel document. Likewise, let me go back to that. With the travel document, the thing is that even if you don't anticipate needing it, you might in the future. So you might, if heaven forbid there's an emergency overseas, if you have not applied for it, then you're going to have to apply for it before you can even request an expedite. So it's going to take that much longer to get the travel document. So that's a consideration. Even if you think you might not need it, it may be worth spending those few $100s to get the travel document just in case. On the flip side, if you are in the United States on H or L, H-1B or L, then those are dual intent classifications. So as long as you have a valid visa, you can use those visas to travel. There are certain requirements, so check with your immigration attorney before you do this, but you can travel on those visas, the H-1B or the L, even if you have the I-485 pending. So in those cases, you probably don't need the travel document. Again, talk to your immigration attorney and come up with a clear strategy. For the work permit, the employment authorization document, same thing. If you don't plan to work in the United States, let's say that you're a spouse of a US citizen and you don't plan to work, at least not immediately, then don't worry about applying for the EAD. Again, if you want it, if you did find a job, you have to apply for it before you even can request an expedite. But if you don't plan to, then it's fine. Same thing with if you're here in the United States, let's say you're filing an employment-based I-485, and you know that your underlying non-immigrant visa status is going to continue for at least for a while, for another year or two, and you would know that because of the I-94. then you don't need necessarily the work permit. You could use your underlying non-immigrant visa status to continue working in the United States, and that could save a couple $100. So these are considerations. I know that the new filing fees for the most part are not fun. They're higher, they're more expensive, seemingly maybe for less service from USCIS, but here we are. So these are some strategies that you can consider in trying to maximize your immigration filing dollars. If you are a client, a current client, or a future client of Sumner immigration law, these are the things that we will help you talk through and think about and make a strategic decision that is the right decision for you. I hope that you will follow us on YouTube so that you don't miss our next video about an immigration topic like this for employment-based and family-based filings. Until next time, my name is Emily Sumner.